Good afternoon, everybody. I'm Mark Rogers along with Vince Angermeyer, but I'll be your MC today. We're going to have 7 segments today. They're up on the screen, starting with upper left. I'll give you an office update on what's going on at the office that may matter to you. Brenda Schleiss and I will be speaking about an update on the Secure Act. You may remember last year it was pending legislation. Now it's been passed, so we'll give you a heads up on what's going on there. Stacy Vogeltons will be speaking about long-term care planning, followed by a joint presentation by Vincent and I about the practical side of your healthcare power of attorney. And then Roman Wojnacki will be taking care of a discussion on passing tangible personal property, something that can cause lots of issues with families. And he'll give you some tips and ideas on what you can do to make sure that goes smoothly. And then finally, I will finish with a segment on what successor trustees need to know. And then at the end, there'll be questions. Right now, I think all of you either are muted or should be mute. But we will have a question session at the end. If you can, you'll find a chat button, and you can either put your question in the chat, or you can just say, I have a question. And our producer, Joe Minicol, who's in the room with us, will see to it that we get a hold of you on screen here and answer your question. So let's go ahead and proceed with the next slide. This is the office update. There we are. And so this is our support staff layout. The important thing to see is in the left-hand side, we have recently hired Katie Soderlund to be in charge of new plan development and serve as our paralegal in that regard, replacing Claire Guest, who's been here for years. She's recently found a job in the field that is closer to her heart in the area of social work. Our receptionist remains the same. It's Patty Tesmer. Client services, Annette Geiger, who is largely responsible for getting things off the ground on this program. Trust administration, when somebody has passed away, our paralegal there is Tammy Rundle. And then we've got 2 support clericals, Grace Adams and Michaela McCormick. Next slide, please. Oh, we went too far. There you go. No, back to the attorneys. There it is. So the attorneys, what we've done here is we've shown you what areas they're working in. Everybody does trust and estate planning, all 6 of us. And then on trust and estate administration, most of that is done initially by Roman and I, and then Amanda McCormack assists, and Vincent Angermeyer also is going to be working on probates. And then last is elder law, but it's certainly not the least thing. And that is done primarily by Stacy Vogeltons, and I chip in wherever I can to help her out. So that's what the attorneys are doing in the office. Next slide, please. Now, you may have heard that there's a COVID outbreak. So we have obviously had to adapt what we're doing to so that we can meet with any of you safely. Most meetings are conducted by telephone or on Zoom until we have to get to the point where we need to sign things, and there we'll need to have you come into the office, but we have procedures to help keep you safe. We also want to remind you that our website now is live. We were planning on combining the estate planning and Social Security administration side websites. They used to have separate websites, but now they are a single website. So we hope you will enjoy that. And then next slide. Just to review, we did at last year's program, let you know that we were going to go paperless starting January 1, 2020. We have done that. So for new clients, everything is paperless. Some of you who have been in for a signing know that we sign, we scan, and then the original that we keep is shredded, and you would go home with your original. And for our current clients, when a new project comes in, that is handled entirely paperless. But we have obviously been slowed down in cleaning out those older files by COVID. So not much has been shredded for those of you who are current clients. Now we're ready to move to a new segment. We're going to talk a little bit about how that new Secure Act that was passed at the end of last year works. On this presentation, I'll be working with Brenda Schleiss, and she will be taking the first couple of slides.
Sorry, I was muted there. So as Mark said, the Secure Act has to do with IRAs and how we take money out of IRAs.
Speak up.
Now that it's gone, we realize that the prior law for inheriting IRAs was really pretty good. We used it in estate planning to pass money from one generation to the next generation. So if husband had an IRA and he left his wife as the beneficiary, she could roll over his IRA and make it her own IRA. Then she did not have to take required minimum distributions or RMDs until she reached the age of 70 and a half. So she could sit at that IRA over her own lifetime, deferring the income tax that was due for as long as possible. If husband left his IRA as a beneficiary to anybody other than his spouse, say to his kids or to trust for his kids, the kids would have to start taking RMDs the year following the year of death. And it didn't matter how old they were, but they could, however, use their own age expectancy, their own life expectancy. They could use their birth dates to calculate their RMDs for the remainder of their lives. So this left us with an opportunity to pass money from generation to generation, allowing a lot of growth in IRA assets, as well as a lot of tax deferral. Next slide, please. Joe, next slide, please. Thanks. So the government got tired of that game, and they passed a new law in December of 2019 called the Secure Act. The cumbersome name is Setting Every Community Up for Retirement Enhancement, or SECURE. The law passed the House of Representatives in May of 2019, and then in December of 2019, the Senate scraped it by. It started being used on January 1st of 2020, so only 11 days after it passed. The government really wants their tax money now. They don't want to have to wait from future generations. For the 2020 year, though, the IRS has said that people do not have to take RMDs from IRAs, SEP IRAs, simple IRAs, 401k plans, 403b plans, 457b plans, because of the financial struggles that people are facing due to COVID. This rule came under the Coronavirus Aid, Relief, and Economic Security Act, or the CARES Act. Joe, next slide, please. Thanks. So a summary of the current Secure Act includes the following changes. At the age at which you have to start taking your RMDs changed from 70 and a half to age 72. You can continue to make contributions to your IRA as long as you like, so long as you're employed. There's no cutoff anymore. You can continue to make contributions even if you're taking RMDs. You can now take $10,000 out of 529 plans. Those are plans set up to save for higher education. You can take $10,000 out of those plans to pay off student debt. After having a baby, parents can now each take $5,000 from IRAs without any penalty. So if my husband and I had another child, he could take $5,000 from his IRA and I could take $5,000 from my IRA without penalty, even though we were taking it before we reached the age of 72. Now, the most important change from our viewpoint is that they eliminated the lifetime stretch out with some exceptions. And Mark is going to talk about those exceptions.
You ready? So in continuing now what's in the Secure Act and what's going on, as Brenda said, the most important change that we see is that now instead of being able to pull money out of an IRA slowly, that's what the stretch out is, over the life expectancy, year by year of the beneficiary. Now it all has to come out within 10 years of the date of the plan participant. There are, though, very important exceptions. I think we need to see the next slide. There it is. And those exceptions are there in red the terminology is an eligible designated beneficiary. It used to be that there was a term called a designated beneficiary, and that is still in effect. We still have to make sure that any money coming from an IRA into a trust pays to an individual who we can identify. However, there are certain classes where we, instead of having to pull things out over the 10-year rule, we can pull it out still over life expectancy. One of those exceptions is the surviving spouse. But ordinarily, the surviving spouse is going to do a rollover of the IRA and be able to continue to use life expectancy that way. But the other three exceptions are ones that we need to pay attention to. That is minor children. We're not sure how that's going to be defined. In our state, you are a minor until you're age 18, but the federal government may say it's going to be age 21. But at any rate, while you're in your younger ages, your child can pull that money out over life expectancy until they hit the age of majority, and then the 10-year rule kicks in. Another exception is for disabled or chronically ill individuals. Typically, these are people that have already gotten a finding of disability from the Social Security Administration. And for those of you who are out in the audience who have special needs children, that's what we're talking about. So we can still use the life expectancy of a special needs child. And then the last exception is for a beneficiary no more than 10 years younger than the plan participant. Let me translate that into plain English for you. That's typically going to apply to a situation where you don't have children, or you're not going to leave everything to your children. You may want to include a brother or sister of yours. Those people are typically going to be less than 10 years younger than you. And so we can use their life expectancy. Now, our concern about applying these rules is when this money gets pulled out and comes into a trust, like a trust for your beneficiary, we may lose the asset protection because the income tax pain is so great that we'll want to pass the money out of the trust so that it can be reported as income on a personal tax return at a lower rate. So that's something that we have to figure out depending on the size of the IRA and the importance of asset protection. And then last is that we're concerned that because of this 10-year rule applying in so many situations, that we can't take advantage of leaving money to a younger generation. But in a second, I'm going to tell you that there's a workaround. It's not perfect, but it's helpful. So let's go to the next slide. So we might need to update your plan or your beneficiary designations and consider the idea of having a separate standalone IRA trust. But we would typically do that for, again, larger accounts. The second thing that you might consider doing is knowing that Roth IRAs are still a good option because the beneficiary does not have to pay income tax as they pull the money out. Even though they might have to pull it out over that 10-year time period, it's not going to cause any pain in terms of paying income tax. This is something that you want to talk to your financial advisor about. If you've got sizable IRAs, you'll want to consider having some of that money be rolled into a Roth IRA, but the planning would be done ordinarily working together with your accountant and your financial advisor. And now here's our workaround, item 3 on this slide, and that is we can consider leaving IRAs both to our spouse and then to multiple other beneficiaries. So you take a large IRA and you basically cut it into pieces. Your spouse will not usually have any extra income tax burden, and then you can take some of the money, spread it over several beneficiaries so that several people are reporting the income tax that come when that money is pulled out of those accounts. So the adjustments we're going to have to make, and we'll have another slide on this later, are we either need to change your plan because there's some things that may need to go in there to make sure that the eligible designated beneficiary can use life expectancy, or we may need to change the beneficiary form so that we are directly naming the trust that you set up for your beneficiaries. Now, at this point, that's the Secure Act update. Again, we'll talk at the end about should you come in for a review on that subject. But now let's move on to Stacy Vogelton's and the long-term care planning.
Thank you, Mark. Good afternoon, everyone. Thanks for joining us this afternoon from your homes. So what I'm going to talk to all of you about today is long-term care planning. For those of you who have attended this event in the past couple of years, you've probably heard bits and pieces of this, but we're just going to do a quick overview of everything today, just because it keeps coming up over and over again. We get lots of questions on it. So I'm going to talk about long-term care insurance. I'm going to talk about Medicaid and how to qualify for Medicaid, how to protect assets if you want to qualify for Medicaid. And I'm also going to touch on how to find the right facility for yourself or a loved one. So go ahead, Joe, to the next slide. So first of all, I want to talk about long-term care insurance. And before I mention that, I guess I should tell you what I mean by long-term care in general. Long-term care means any type of care you might need or a loved one might need if you're no longer able to stay at home. So what most people think of as a nursing home, it might be an assisted living, a memory care. It could also be hiring a nurse or somebody to come into the home to help you as well. And so when we talk about long-term care planning, we talk about how are we going to afford that? How are we going to pay for those services or pay for that nursing home? So a lot of people might be under the mistaken belief that Medicare, the insurance you get when you retire and get Social Security, is going to pay for those services, but unfortunately it does not. So you either pay privately or you qualify for Medicaid, which is a different program. Long-term care insurance is a way to help you pay privately. So it's an insurance policy, just like life insurance or any other insurance policy, where if you need long-term care services, you end up needing to go into a nursing home or an assisted living, and you have a long-term care insurance policy, that policy will pay the bills when you move into that nursing home. So this is always our first recommendation. It's going to offer the most opportunity for you because every type of facility, including having a nurse or a helper come into the home, is going to take your long-term care insurance. Whereas with the other option, the Medicaid, not everyone will necessarily take Medicaid. So long-term care insurance definitely offers more options for you. We do not sell long-term care insurance here in our office, but if you have a financial advisor you work with, more often than not, they do sell long-term care insurance. So you could check with them to see what your options are. A good age to be looking into long-term care insurance is probably about when you start worrying about long-term care. So after retirement or around retirement age is a good age to be looking into that. If you don't have a financial advisor or your financial advisor doesn't sell long-term care insurance, we can definitely recommend somebody to you who could give you some quotes on that type of policy. Joe, go ahead. I think you're actually 2 slides. One more. Thank you. Okay, so if you don't have long-term care insurance, or if you've looked into it and you don't qualify, because they do look at pre-existing conditions, they look at your health. Sometimes it's just too expensive with those pre-existing conditions. Then your option might be Medicaid. So again, Medicaid, not Medicare, is the program that's going to pay if you end up needing to go into an assisted living or a nursing home. So what you see on the screen there in front of you is the limit that Medicaid places on the amount of assets you're allowed to have in order to qualify for Medicaid to pay your bills. For a single individual, they only let you have about $2,000 in assets in addition to your house, your car, or prepaid funeral. And when I say $2,000 in assets, that includes everything you've got, your bank accounts, your brokerage account, your IRA, your 401k, all of that, $2,000. On the other side of the chart there, you see what married couples are allowed to keep. They're between about 50,000 and just under 130,000 that they're allowed to keep in addition to those other things. So it's a little bit more, but for a lot of people, still not what they'd be happy with. They don't want to spend all of their assets down to those limits in order to qualify for Medicaid. So that's where our office can come in and help with some planning options. Go ahead, Joe, next slide. So in our office, we can help people qualify for Medicaid when they're kind of looking ahead. So nobody needs to move into the nursing home or the memory care right now, but they're thinking about it. They're wondering if there's something they can do to protect assets. And then we also help at that point where someone is maybe looking to move a loved one, a spouse, a mom or dad, or someone into a nursing home, and they're realizing that, you know, they've waited too long. They find out that Medicare is not going to work. They don't know how they're going to pay the $10,000 a month. We can still help them at that point. So let's talk about what we can do kind of ahead of time. So Joe, if you want to go to the next slide. What we do when we've got a little bit of time is use irrevocable trusts. So I just want to say that an irrevocable trust is different than the trust that most of you probably have. You know, someone in our office helped you set up a revocable living trust, and that's your estate plan. This type of irrevocable trust for Medicaid is a little bit different. So it protects assets from the nursing home, whereas the revocable living trust, or the RLT, will not protect assets. So it's a different kind of trust. But we still set them up in our office, and I'd be happy to talk to any of you about how we set them up and what the differences are between the two types of trusts. But I'm just going to go through a really quick example of how this might work, okay? So in our example, we've got a married couple. We've got Bill and Mary, who are retired, but maybe they've waited a little too long, or they don't qualify for long-term care insurance for one reason or another. So they want to explore some other options to protect assets. Because they want to make sure they can leave something to their son, Bobby. So they've got a house worth $300,000, some investments in a brokerage account worth $200,000, and then a life insurance policy worth $100,000. They're both retired, living off of their Social Security, and that's enough to cover their expenses. So what we could do for Bill and Mary, if they came in and they were looking at doing some Medicaid planning ahead of time, is we could set up this irrevocable trust for them. What we might put in the irrevocable trust for them is their house, their life insurance, and maybe just half of their investment account, so that they still have some money as kind of a reserve fund or an emergency fund in case they need to dip into their savings. So if we move those things, their house, their life insurance, and half of their investment account, what we end up protecting from Medicaid is about $500,000. Now, the last point there on this slide, if you can read it, says that Bill and Mary must wait at least 5 years before applying for Medicaid. Now, that's key, and that's why I say this type of planning is pre-planning, because once you set up this trust, it takes 5 years before these assets are actually protected from Medicaid or the nursing home. So we recommend people set these up in their 70s, mid-70s, again, just to make sure that you've got at least 5 years before mom or dad or husband or wife or whoever it is going to need care in a long-term care facility. So then let's now turn to, if we've waited a little too long and we don't have 5 years, a loved one is going into a nursing home or assisted living now. So the first question, the hardest question, is where do we start? How do we find a facility? What's the difference between all the different types of facilities? You might hear senior living, you might hear independent living, CBRF, memory care, nursing homes. These terms all mean different things, and they all provide different levels of care. We do have a really simple handout that we give out to clients who are at this point in the process where they're looking for a facility, kind of a what questions to ask when you're touring these places or interviewing these places. But that's really as much help as we can offer. We're not experts in this area, but we work with people who are. So we work with a number of professionals who do this full time. They work with the family to help find the right placement for mom or dad or your husband or whoever it is. And they know the ins and outs of all of these different facilities, which ones are going to be the best fit, which ones are going to provide the best care, which ones might be flexible on, rent or move-in dates or things like that. So again, if you're at this point in the process and you don't even know where to start, you can contact us and we can give out a referral to one of these professionals that we work with, which we actually highly recommend that you do that. So then once you've found the facility, let's talk about how we're going to pay and how we might qualify for Medicaid. So here's a different example of how we can qualify someone for Medicaid and still protect assets. So now in this example, we still have Bill and Mary and their son, Bobby, but now Mary is moving into the nursing home. So how are we going to protect assets for Bill and Mary? They still have the same assets. They have their house, their investments, and their life insurance. Under the Medicaid rules, if you remember from a few slides ago, Bill and Mary are only going to be allowed to keep about $130,000, $128,640 to be exact. So what are they going to do with the extra money? And again, this is where our office can come in and help. What we do is we use Medicaid's rules to our advantages. One of their rules says that we can loan money to family members, and once we do that, it becomes unavailable. So in our example here, to get under that $128,000 limit, what we could do is loan about $171,000 to their son, Bobby. Once we make that loan, they're under that magic number, the $128,640, and Mary is going to be eligible for Medicaid. We apply for Medicaid, she gets approved, Medicaid is now paying the nursing home bill every month, and under the terms of the loan, Bobby's going to pay all that money back to his father, Bill, in a matter of, a few months. And so now, after that loan is complete, Mary's on Medicaid, Bill has all of the assets. He has all of the investment account, all the life insurance money. He's kept all of that because it all came back to him from the loan with Bobby. And so we were able to get Mary on Medicaid and still protect about 100% of their assets. So that's an option that's out there as well. And that's all I have for this. We're going to go back to Mark for a second.
So we're moving to a new segment. This is the part about the healthcare power of attorney. Vincent Angermeyer and I are going to be doing this for you. And our thinking here was, because of COVID, this is a document that's actually likely to come into play for some of you. It's often the first document that you start working with in your estate planning portfolio. So what we want to do is understand how your power of attorney for healthcare is set up. And for those of you who don't have a power of attorney for healthcare, you'll want to get this done. So we'll talk a little bit about how it's done properly, what can be in there, and then I will talk about the practical side of things. So I'm going to turn this over to Vince right now.
So before we can really talk about how it works, we need to make sure we're using the right terms, because I think in day-to-day life, a lot of expressions for living wills and advanced directives get thrown around. But because we're lawyers, it pays to be precise about what we're talking about. So a living will is the guidelines for what you want to happen in terms of decisions that have to be made when you're not available to make them. And the healthcare power of attorney designates who the guidance is for, who's going to be carrying out what you want. And then when you combine the two, the advanced directives apply to the group. Now, if you look through your binders, you won't find a living will. That's because we have an article of the healthcare power of attorney, Article 3, that really functions as a living will. Now, in terms of effective planning, you need to have clear directions. Obviously, if the point of the document is to simplify decision-making for people, you need to be clear what decisions you want them to make and what the parameters are. So obviously, it needs to be clear who the agent is. In fact, and in terms of, and also who the successor agent would be if a primary agent isn't available. It needs to be clearly identified, who are you talking about, where are they? Obviously, usually full name is good enough so that if the person goes to the hospital can confirm who they are and start listening to them. And relatedly, it needs to be clear exactly what the agent can and can't do. it can be customized. This is a highly tailored part of the package you get. So if you want them to carry out decisions related to refusing to treatment or discontinuing treatment, which can go so far as checking you out of the hospital, if consistent with your wishes, you wouldn't want to continue being treated there, or you want to move your treatment to somewhere else. It's a big decision, but it's still something you can assign to your agent. Same thing with hiring and firing medical personnel. If that's a decision you could or would make if you were capable of making it, that's again another thing that can be passed on to your agent. And it doesn't need to be a life-threatening scenario. If, admission to a nursing home, that's obviously, or in many cases, that's going to be a decision where by the time it needs to be made, you might not have the capacity to make it in the opinion of your doctors. And so at that point, it'd be good to have an advanced plan in place for who is responsible for making that decision and what kind of guidance have they been given in terms of what to look for when making it, and also where to send you. And then relatedly, just as a last thing, and this would be a basic part of most plans, is being able to get medical information. We keep your information confidential, and unless somebody comes to us with signed documentation from you, we're not sharing it with anybody, because that's our duty of confidentiality. And hospitals have the same thing. They're going to be pretty limited in who they're willing to share medical information with until they have something in writing from you, giving clearance. Now, just like the identity of the agent can be tailored, so can the guidance. And so in most cases, in most of your plans, there'll be a general expression that you do want to be kept comfortable, and that to some degree, you don't want to prolong the inevitable. Although, in working with us, you will have kind of tailored out exactly what you mean by prolonging the inevitable, or what kind of opinions need to be gathered, or how much time you're talking about. And that can be further, the default is prolong as long as possible, but obviously there's an escalating series of measures you can take to shorten that. So if you have entered a permanent vegetative state and permanent loss of consciousness, if your healthcare power of attorney is giving direction to your agent to have that be a trigger where you might have a do not resuscitate in place, or a no code, that can be in there. And I'm sure your agent would appreciate having that kind of guidance, and not feeling so much weight because they know what you want. Same thing with a terminal condition, where you might still be around, but your agent can still help you with the decision making, or if there's a crisis moment, can act on it. Similarly with severe dementia, and by severe, we don't just mean having trouble with directions or having trouble with word finding. I mean, that we're really talking about the degree to which you might not be recognizing family members anymore. Again, that's a situation where the family members, if they're your agent, might really benefit from some guidance from you. And then really about as far as the plans can go would be where you reach a point where quality of life is unacceptable. It's not quite life-threatening, but because of your personal preferences, and this isn't in most of the plans we made for clients, you can still put in do not resuscitate and no code orders if say you become fully paralyzed, or if you're otherwise bedridden, and things like that. That needs to be a discussion. That's something we would really want people talking to us about and really thinking through, because it is only in some of our plans, and we really do ask that it be fully thought out before that goes into the plan. And with that, I'll turn over to Mark.
So what we're trying to do is tell you what the technical side of your document looks like, why these things are in there. But many of you know that we also speak about the importance of having things be practically effective. So we're going to talk about how things work in the real world, and some of these things that aren't so technical or legal. The first thing is, how do you pick a healthcare agent? So those of you who are our clients already know that we've helped you through this process. Some of you in the audience haven't gotten your estate plan done, so you'll learn a little bit about how we'll help you approach this. Well, we often, if we're going to name a healthcare agent, somebody who's going to stand in our shoes making healthcare decisions for us, you want somebody who's close to you, and those are your relatives. It's going to be your spouse, your adult children. It might be your brother or sister, but those are the people that are going to know you and care about you. But when you're picking an agent, you also want to make sure you have somebody who's actually going to follow the guidelines that Vincent just mentioned about terminating healthcare that's not going to help you get better if you're in a coma or suffer from severe dementia. And so some people get a little squeamish. And so you want somebody who is going to have the strength to say, I think it's time to say no, no more care at this point. Distance is a factor, meaning how far away is your agent? If they live in California and you're here and you're in the hospital, sometimes being physically present is an important thing. And so, but we do want to pick the son or daughter, brother or sister who's going to make the best decisions, but distance is an important factor. The phone can be a practical alternative, and we do mention in the documents that we prepare that either communication from the agent by phone or fax is acceptable. Let's go to the next slide. More practical tips. This is, even though you're going to be setting out guidelines in your document, it's important to talk to your family about what you have in mind so that they, again, feel comfortable when they're having to act under this document at a time when we probably can't communicate very well with you. We want to make sure the healthcare power of attorney as a document is where we can get at it. I always tell clients when they come in now that because this has been my experience, every time something bad happens to you medically, it's Friday or Saturday, and you can't get a hold of your doctor and much less a copy of the healthcare power of attorney. So we make paper copies when we do a plan. We get it to your primary care doctor and specialists. We want to make copies for your agent and encourage you to pass those out. We want you to keep it in your car. Just in case somebody is driving to see you, they'll have a copy of the healthcare power of attorney. If you've got a second home, a vacation home, or you're a snowbird, you want to keep a copy in both locations. And then for those of you who haven't gotten a plan done, I know you can go on the internet and take a look at the forms, the free forms that are available. But I can't stress this enough, how important it is to get counseling, to get some advice on how to fill that form out, what boxes to check on those forms, and what guidance that you might want to leave about these end-of-life issues. If they're not worded right, it can create a horrible mess. So again, please get some counseling on that. And then last but not least, we've got some tips for snowbirds. Those of you who are smart enough or lucky enough to be able to get out of here when it gets cold. Typically, most people are heading to Florida and Arizona. And we think even before you leave, if you're going to spend a lot of time in one of those locations, that it might be a good idea to have us draft an Arizona or Florida healthcare power of attorney. And again, it's a practical issue. Legally, the document that you've done up here is valid, but try to convince the clerk at the front desk at the hospital you're checking into in Florida. They're not going to be sure. They haven't seen one that looks like yours before. Oh my gosh, it's talking about Wisconsin law. What do we do? And so it'll get kicked upstairs to some legal department, and it'll just slow things down. So in order to speed up the process, we just draft a power of attorney that looks familiar to the local folks. So those are the practical steps that we take in order to get that power of attorney actually effective for you. And now we're ready to move on to one of my favorite subjects, and that's divvying up the pots, the pans, the furniture, the jewelry, the clothing. And for this, we have our friend Roman Hoynatsky.
Did you want to talk about anything COVID specific for HCPOAs?
Mark, are you going to respond to something first, or do you want me to
What
take up?
did you want to say, Vince? Go ahead and just say it.
Well, I think we had added, we were going to talk slightly about how COVID ties into all this. I think it was supposed to be in my part. And then
That's all right.
I tossed it over to Mark without talking about it. Now, obviously, HCPO, healthcare powers of attorney are more relevant because of COVID, because it's a new reason you might end up in a hospital. But we all know that already. The real issue, especially for people who don't have one yet, is that HCPOAs are one of the hardest forms to get completed properly in Wisconsin that there is. It's up there with wills, in terms of the requirements for who signs it, because there's limits to who can sign it. You cannot have family members or anybody who stands to inherit from you be a signatory to your healthcare power of attorney. And none of your doctors who are providing care can sign it. So that can be an issue if, somebody who's not fortunate enough to already have an HCPOA in place ends up in the hospital due to COVID, because their doctors, who are probably the only people in the room, cannot be signatories. And maybe in the past, you could have snuck in a janitor or something like that to be the signatory. They're probably not going to do that anymore. And it's going to be harder than ever for family members to get in to take care of it, especially if they don't have an HCPOA in place, but especially because of the contagion factor. So more than ever, this really needs to be thought out in advance. And it's also for people who are already in advanced care facilities that are in lockdown now. You really need to be making plans well in advance about how you're going to get people in there to serve as a witness to this. And even though, more and more things are being done remotely now, and some practices or, say real estate signings can happen remotely or be notarized, over webcam and things like that. That's not the case in Wisconsin. The law doesn't allow for that, and the regulatory agencies really have made a conscious decision to not let signings happen remotely or by webcam. So in addition to being more important than ever to have them, it's really harder than ever to get them completed in compliance with state law. And so if you know anybody who might not have these documents in place, or if you yourself have updates that you want for your power of attorney, it really pays to think ahead now more than ever. And that's all. That's it. Sorry, Roman.
Oh, thanks, Vince. Thanks, Mark. So thank you all for joining us today. And I certainly hope by this time next year, we'll be sitting down together, enjoying meatballs and smoked salmon. So today I'm going to talk about personal property distributions. And I can't promise you that this is something that's going to avoid family fights, but it's going to diminish them. So what are we talking about here? Personal property distributions are allowed because the Wisconsin probate code and the trust code allow these. And we're talking about the things that you can put your hands on, tangible personal items. As you can see on the slide, we're talking about your household items, includes automobiles. And sometimes these items don't have a great deal of financial value, but they have a great deal of sentimental value to your family and your friends. Now, in the plans that we draft, either a will or a trust-based plan, we have our own definition of tangible personal property, which pretty much is consistent with what the Wisconsin law is. Next slide. So the ways that this can be distributed is by a memorandum. You could leave it up to your trustee or your personal representative, or you could do a combination of both of these. Next slide, please. So there you see a memorandum for a married person, and that's for a trust. If you have a will, it'll be very similar to that format. Now, for a married couple, there's a third column where the asterisk is shown, and the reason that that column is there is, say you have a married couple and the wife dies first, and there's a dining room table that's supposed to go to a daughter. Well, you'd want to indicate that that does not get transferred if the husband survives, because he's probably going to want to still use that table. In other instances, there might be hobby equipment that the surviving spouse no longer needs, and that could be distributed to a beneficiary right away. Now, this document is usually in the last tab of your trust binder and the last tab if you have a will binder. And I noticed when we do our reviews, and now I've been doing these trust reviews for over 10 years, and very seldom do I see these forms filled out. So I hope I can encourage you to take a look at these and maybe take a second look at whether you should fill these out ahead of time. Next slide, please. So if the memorandum, and it's not normally going to cover everything unless you make a blanket statement that says all of my tangible personal property to such individual, it's just going to highlight those items that you're more concerned about. So if it doesn't include everything, oftentimes we'll have language that'll say that your children or other individuals should receive the tangible personal property in substantially equal shares. And we try to give them an opportunity to agree to the things that they want. Next slide, please. If the recipient is a child that can't make their own decision, normally we'll have a provision that someone can step in and make a decision for those children. And if at any rate, no one can decide within 6 months of the death where the property is going to go, then the trustee can make that decision for the individuals and is held without responsibility for the specific distribution, as we can see in the next slide. So the trustee then, and the same would go for the personal representative, can come up with a system such as a lottery system, rotating who makes choices, anything that really is fair under the circumstances, so that individuals that are supposed to get an equal distribution of this type of property are treated equally. And then also, after the items that are distributed that the beneficiaries want, then the balance can be sold, and the proceeds from the sale would be split in the proportion to the provision in the either the trust, the will, or in the memorandum that talks about how things are supposed to be split up. Next slide, please. So this is what I was talking about before. The trustee is held harmless as long as the trustee or the personal representative uses good faith in helping to transfer the property. For instance, oftentimes the trustee or the personal representative will also be named as a person that's going to receive some of this property. So if they make decisions that benefit them and don't benefit their siblings or other relatives equally, there might be a problem. But normally, if they're trying to do their best to treat everyone fairly, there's not going to be any issues with this memo. Next slide. So the whole idea here is to take advantage of a planning opportunity that can avoid a dispute. Now, we can't assure you that if you fill this form out, that everyone is going to agree to the way they were treated. But oftentimes, coming from you, it'll have more weight as to where property is supposed to go. So again, I urge you to look at in the last section of your trust binder, or if you have a will-based plan, the tab that has the memorandum there, and take a second look as to whether you should fill that out and help your trustee or personal representative from having to make all of the decisions in this regard. Thank you very much.
All right, so now I will be doing the last segment. You're seeing a photograph of Amanda McCormack. We wish she were here today, but she has family issues to take care of. So I'm going to pinch hit for her on what successor trustees should know, a refresher. So what we're going to start with, and Joe has put up the first slide, is we're going to think about the kind of planning that we're doing when we're using a trust. And you may remember that we want to be prepared for the possibility of incapacitation, and we want to get things to the right people in the right way when a death occurs. So a trust is a good tool for incapacity planning because we get to name a successor person who will take over the management of our assets. We continue to be the primary beneficiary of a trust even when we're incapacitated. And a trust is the best tool for leaving detailed instructions about how to spend our money on ourselves and to assist others in the family who may have run into a rough spot. So that's why a trust is good for incapacity planning. And then for death planning, a trust is going to avoid probate. We're going to be able to get our distributions done more quickly than if we run through a probate. We use it for tax avoidance, not only avoiding and reducing estate taxes, but also now we're giving thought to capital gain tax to make sure that that gets erased if somebody passes away so that assets can be sold without paying the capital gain tax. And then a good trust can provide asset and lawsuit protection for the beneficiaries, not for you when you're setting it up, but as you're passing money and property down to your spouse or then to your children, you can gain that sort of asset protection. And then we can use the trust to make sure that things get to your family in the event of a remarriage. That's what's keeping the assets on track. And we might want to create lifetime trusts, protective trusts for our heirs, which are usually our children. Next slide. So what we're going to take a look at is what's involved in a trust administration when somebody does pass away. And so one of the first things we want to know is where is that red book? And so those of you in the audience, I used to, when we did this program live, we would have you raise your hand if you knew where the red book was. So just if you're sitting there with your mom or dad, make sure you know where they keep the estate plan so that you can find it. Once we find it, there's going to be a sort of 4 steps to getting an estate settled. And you're seeing the first 2 on this slide, and that is we've got to prepare an inventory of the assets and debts. We want to file claims. Filing claims means going after the IRA money, the life insurance money, that kind of thing. And so our office would assist you with that. We have to pay our administrative expenses, court costs, attorney's fees, and so forth as part of settling the estate. And next slide. And then on this slide, you're seeing the last 2 of the 4 stages: preparation of taxes and the distribution of the estate. There are 2 taxes that we have to start paying attention to when a death has occurred. That last final personal income tax return, and then there has to be what's called a fiduciary income tax return to cover the time period from the date of death until we get the estate where it's supposed to go. And if there's any gift estate or generation skipping tax, we work on those tax returns as well. And then there's a preparation of a final accounting. If we're making a distribution to the 3 kids after both parents have died, and we only have one of the kids serving as trustee, if I'm the other 2 kids, I want to know how much money did you start with on the date of death, and how did you get to the point where you're actually writing us a check? What were the expenses? And so that's something that a trustee needs to do. But most of these trustee duties, you should understand, we will help you do so that you don't have to do them all by yourself. And so the distribution phase, if we were doing, going to set up a trust for the kids, that's when we finish doing that. We get a tax ID number, an affidavit of trust. So that's the big picture on the settlement of the estate. Let's talk about some of the different things that trustees need to know. And so when can we distribute the assets? Well, we should make sure that the debts are paid. We shouldn't make a distribution without getting proper advice. Occasionally, we have a situation where one of the beneficiaries is in need of money, but the other two don't. And then do we have to wait all the way to the end of the process to do the distribution? And the answer is no. We can do partial distributions, but again, we want to do that with proper advice. And what we want to make sure of for you as the trustee is that you're not going to make a distribution of all the money and then have a debt come in that needs to be paid. That can be very difficult to retrieve money that's already been distributed out. You want to go to the next slide. Do you get paid for being a trustee? Well, you do. Pretty much every trust we do will say that the trustee is entitled to a reasonable fee. And it really depends on what you're doing. Are you helping during a period of incapacity, or are you winding up an estate after the death of a parent? The fees will be slightly different. And these understand that these fees are reportable on your income tax return. If there are disputes, the court is always there to help us resolve those. And you don't have to take a fee. So a lot of times a surviving spouse won't take a fee. Sometimes we have brothers and sisters who are winding up the estate and they will not take a fee either. But that's up to you, and that is something that we discuss. Next slide. So the trustee is a fiduciary. And what that means is you have an important legal duty to take care, to follow the instructions that are left in the trust. And you want to determine if you think any work is needed. You may not be able to figure that out right off the bat, so you want to call in. So we've set up dozens and dozens of trusts now where we have simplified the process at the first death when we have a married couple. But it's still a good idea to call in. We may only need to help you a little bit with putting in a claim for an IRA or a life insurance policy, but there may be little or nothing else to do at that first death if that's how your plan was set up. Next slide. So when you're a trustee, you're required to act because of your fiduciary duty in the highest good faith. That means basic fairness, ordinary care, and diligence is required. But that last point that you see on that slide is important. Some of you may have noticed that the market is rather volatile and has been for probably more than a year, but COVID didn't help. And so we get people that there's been a death, they come in and there are either in IRAs or in brokerage accounts, significant number of stocks and bonds. And the question is, do you want to ride it out while we're working on getting the estate distributed, stay in the market, and run the risk that your family will be very unhappy with you if the market heads downward? So a lot of times we want to liquidate the accounts so that we turn it into cash, and then we don't have the volatility. But it is something that we discuss individually with each family. Next slide. So once again, the trustee is supposed to follow the instructions in the trust agreement. That's very important. Carrying out the wishes of the trust maker, but those wishes should be in writing. We have occasionally families will come in and they'll say, but mom and dad wanted this or that to happen, but it's not in the document. If the family is definitely in agreement on that, we will try to find a way to make it happen. But it is important, if you do have wishes that you want carried out, that you say it in writing in your document. In our state, this is the last point you're seeing on the slide. There's a new duty for trustees to inform the beneficiaries when the trust administration is open. We want to provide them with a copy of the inventory so that they know what's going on. Next slide. Are there things you shouldn't do when you are the trustee? Well, I guess it's common sense. You need to realize it's not your money. You're managing money. You're managing money for somebody else, and so you can't make loans and gifts and donations to yourself unless the trust authorizes that. And I should tell you, in most situations, we do, that is authorized because we are naming our sons and daughters as successor trustees. So on the next slide, you'll see more things you shouldn't do. So we don't want to take advantage, even though we legally could. You want to be fair. We don't want to mix or commingle property, your own property, with the property in the trust. And then next slide. Do you have to do this all by yourself? And the answer, thankfully, is no. It sounds like I was just describing a whole lot of jobs that you have, but you will be able to get a lot of assistance from us. And then occasionally we'll need the help of your accountant or tax preparer, the financial advisor, and the insurance professional, and possibly a care manager. So these people are all in place to help out. And if they're not there, we'll help you get appropriate people. So what are the reasonable costs of these services? They are paid from the trust assets. The attorney's fees can range from as low as half a percent of the size of the estate up to 2%, depending on the difficulty of what we're doing. But I can tell you that's saving at least a percent or more compared to going through probate. So although it's expensive, it's a whole lot less expensive than going through a probate. So when you are ready, you would call in, and then we'll take a look at your trust and help you understand how to operate things. So let's move toward wrapping up a little bit. So we're going to talk about what our services are, just to give you a reminder of that. We'll talk about whether you need to do a review, and the comment cards aren't going to be comment cards this year. This year, you'll want to contact Annette by phone or email to ask for a review. So we'll go to the next slide, and here's a summary of our services. And almost all of you're on this program because you've used our estate planning services, but we also do elder law. That's the Medicaid eligibility things that Stacy was talking about earlier. And people sometimes just don't realize that we do that kind of work. So we want to remind you, you're fine now, but in a year or 2 years, if your health starts to decline, somebody can get a hold of us, and we may be able to help protect money and get you eligible for Medicaid to pay long-term care costs. Obviously, we do trust and estate administrations, and there's tax planning that is involved with every phase that we're talking about. So on the next slide, you're going to see, we're going to talk a little bit about who should get a review. If you are married and have a joint trust and you have not changed your trust to a disclaimer trust, maybe you shouldn't, but it's not a bad idea to look to see if you should. So if you're wondering if you have the right kind of trust for the current circumstances, feel free to call in. If your plan hasn't been reviewed in 2 years or more, you might want to come in. Things have changed and improved. So you may want to allow your children, this is the 5th point, to act as sole trustee of the trust that you've set up. They'll still get asset protection because of a change in the law that occurred in 2014. Our 4th point, what if your kids have what are called installment trusts? You can usually tell that by looking at your color flow chart. And if you see on there that it pays out at 25, 30, and 35, I'm going to guess that your trust was done in the late 90s or the early 2000s, because we have not recommended that kind of planning for quite some time. And you'll want to probably update that. And then the last point is, if you're concerned about long-term care costs, sometimes when you came in, you weren't concerned at all. And after 5 or 10 years, you are now concerned. So that is something that we can always talk about to see if we need to do some long-term planning for you. On the next slide, This is going to tell you a little bit about what we'll be doing. It's important often to update your financial power of attorney. We now include some language about managing digital property, digital devices, and online accounts. So that's sort of new stuff. And we always update the Medicaid tools that we use to help get you eligible. On the trust, once again, we want to make sure that digital property can be managed. We want to make sure that we're always getting that step up in basis. In other words, avoiding unnecessary capital gain tax. That's sort of the new thing that we worry about at this point. And then allowing your kids to serve as sole trustee and making sure that even the kids, if they have a trust and is passing to the next generation, are going to get a step up in basis. And one last thing is that these days we're doing a new assignment of tangible personal property that includes assignment of control over digital property and digital devices. And now, what about the Secure Act? So our question is, do you have one of those eligible designated beneficiaries, a minor child, a disabled beneficiary, or a beneficiary who's no more than 10 years younger? Please feel free to call in, have us see if there's something that we can and should be doing to improve our ability to pull that money out more slowly than the 10-year rule. And so the adjustments we make, sometimes the trust has to be changed so that it becomes a thing called a conduit trust. In plain English, what that means is a conduit trust is a trust that says if money comes out of an IRA into the trust, then it has to be immediately distributed out to the beneficiary. And so that sometimes will save us from the 10-year rule. And then the other thing that we do is we adjust the beneficiary forms. Instead of naming the main trust, the Joe and Mary Smith Living Trust, it will name the individual trusts that were created for the kids, again, to allow them to do a stretch out. The next slide is just a list of our locations. And then finally, we haven't moved at all. We're still in the same places. We do most of our signings here at the Milwaukee office because we are configured that way. Holy smokes, we don't have any more questions. I miss seeing everybody. And I hope you all have a safe holiday period here. Take good care of yourselves and each other. And feel free to call on us at any time. We'd be delighted to help you. I want to thank all the presenters, and I really want to thank Joseph Minicall and his wife, Anna, who showed up today to help us make this program run as smoothly as it did. So thanks so much, everybody.